Hello, my name is Joseph Rory, and I am with the Madison School of Common Law. Today I'm going to be as brief as possible, probably try to make these shorter anyway as much as possible, but I'm going to talk about the Marbury versus Madison scam. Put emphasis on that because there's a lot behind that we need to know about. Now the Marbury versus Madison case, if you could call it a case, Jefferson was intrigued that they was calling it a case and made comment about it. The background behind this Marbury versus Madison case and why it is considered a landmark case is because the Supreme Court uses it to this day as their so-called power of judicial review. In other words, the ability to make the decisions of what is constitutional and what is not. And that's above the states as well. And so we want to get into the background of this. That was in 1803. Now, in 1799, James Madison at the Virginia Convention had made a statement, which I have obtained a certified copy of that convention. He made a statement that there was no higher court in the land than the state courts. Now this was the understanding of Madison, along with pretty much everybody. And but at least we've got documentation of Madison saying it, which, you know, he's been given the credit of being the father of the Constitution. Well, Thomas Jefferson wasn't really that strong on this judiciary stuff that was going on. He had his reservations quite a bit on the power of the Supreme Court, which they didn't get much anyway. If you look at the Constitution in Article 3, you'll see that in Article 1 the legislature's got quite a bit of power. Well, not considering, but still compared. The legislatures received quite a bit, the executive branch received quite a bit, but the judiciary basically got the crumbs of the table. And there wasn't a lot given to them. The Supreme Court has invented their own powers pretty much throughout the ages, decades, and etc. The Article 3 is pretty slim as far as power given out. We have the Supreme Court Justice John Jay, which was the first Supreme Court Justice. Now, he gave up the job so that he'd go back and be governor of the state of New York. It really wasn't impressive for what their job was. And I think if you're any kind of a historian at all, you should go back and look at this and see just what it was, because what I'm going to be showing you in the videos in the future is how everything changed, especially after the war. Oh, there was a few things going before the war, but the traffic flow of new ideas and the contaminations of the so-called new rules, the ratified 14th Amendment forced down the throats, the military power. We'll get into all that in the future, but right now let's stick with Marbury versus Madison. The Madison had made that statement, and you got to wonder if maybe Marshall, which was the Chief Justice in 1803, didn't think that maybe he should curb that idea for our country to have a new principle of thinking. But in just a few years before this case showed up, and I'm going to go ahead and call it a case, but officially it's not one. You will find out. The Adams administration was going out. The end of the day was about it, and Jefferson was going to be taken over. Now, they knew Jefferson's idea on the judiciary. They had already wanted to appoint 16 other judges and give them commissions to be seated in various departments. And knowing that Jefferson was not going to let this go through, they worked up until midnight to get these judges commissioned and then sealed by the Secretary of State. So, working to midnight, and this is why they're also called the Midnight Judges, they left the commissions on the desk of the president, which the new one would be Thomas Jefferson walking in. And so here's the commissions for these judges to receive. And Jefferson tells Madison, don't deliver them. That would incomplete the process. An old maximum, which is called infere, French maximum, and it's meaning incomplete. And it basically, under the common law, meant that if you didn't complete the job, then it's not a job done, and so it's not completed. So these commissions, if they're not ever delivered, these judges would not be able to take the seats. So, of course, that disturbed everybody because Madison would not deliver. And so they filed a writ of mandamus. Now, this would be an original action. The Supreme Court did not have jurisdiction but to handle this in an appellate matter. And so the Jefferson and Madison, knowing that there was some kind of a disturbance as far as something going on over there, it was considered a mandamus to make the Supreme Court order Madison to deliver the commissions. Well, first of all, they didn't order them. They had some compromises, but neither Jefferson or Madison showed up for the hearing because they knew the court didn't have jurisdiction. The court knew it didn't have jurisdiction and even said so in its writings, in its so-called decision. Now, this is the decision that has given the court the so-called superpowers of deciding what is constitutional or not. One of the problems that we do have is that the Constitution is not necessarily really silent on the matter. It is, in the sense that the final wordings do not give any power to the Supreme Court to do that, nor does it give it to the executive or the legislative branch. It could be that we may ought to just settle for the fact that all branches should be able to make a proper decision on the Constitution. I wouldn't put that in the hands of anybody today, but in those days I think they tried as hard as they could to come up with what they wanted. Well, the interesting thing about this so-called self-given powers is that the Constitutional Convention, when it was in session, there was 2 attempts to give the court that power, and it failed. Now that's fair enough. If you could go back to the convention and read it for yourself, and they're pretty interesting readings. I mean, a lot of us, I think need to be reading Dr. Zeus or something. I'm not sure what everybody's reading, but it's time to get down to what is truth and what is law and what is not. But reading the convention, you will see that it was raised twice to give the Supreme Court that power, and it didn't make it in. So that's fair enough. I think I can understand, well, then the court, if nobody else has got it, we know that the court doesn't. So this is basically the uproar that is giving the courts this so-called power. And of course, you're hearing it's common practice today that the Supreme Court has ruled this, the Supreme Court has decided this, the new law of the land. Well, see, there's power problems when you think of the court having that power because it's basically ex post facto. There's no law in ahead of time because generally they're behind getting the case after the fact is over. So for them to be able to legislate some kind of a law out of this and make it mandatory upon the people becomes a big, serious problem when it comes to separation of the powers, as we are taught. Now, whether we really did that or not, There's actually nothing in the Constitution that says that. It seems to be implied, so we can sort of live with that since there was a separate power for the executive, or a separate power for the legislature, a separate articles for the judiciary. You sort of get the implication there. But the courts today, like the changes of civil rights, and boy, do they talk civil rights. It's a corrupt, as far as I'm concerned, it's defrauding the people to bear down on them constantly, the civil rights, your civil rights. I had a judge one time to come up to me because he knew I was a little belligerent about my rights and this so-called little case they had on me here. And he comes up to me, which he's not supposed to, but these judges, they do what they want to do. And he comes up to me during a recess. He says, "Don't worry, Mr. Rory, I'll be glad to protect your civil rights." And I told him pretty fast. I said, "Don't even think about it. I don't have civil rights, don't want civil rights. I have none to protect." And he stares me down a little bit because he's not sure what I mean, and I'm sure he didn't know. He not even a surety. He just didn't know. He was just one of these little magistrates in these little, I don't know what you call them, courts. They put them up. I've been in courts where they have the little trailers, So we've got quite a bit going on. We deceive the people as a government out here, making everybody believe that this is a court, this is a court. So in the future, we will come up with the definition of court. We'll find out what a real court is versus all these administrative courts and legislative courts. All of these that are made in their own place, and especially by consent, be part of the system. But they do not have what we're going to be teaching in the future on due process. They have their version of it. They have their defined version of it. We've already read into definitions. That's what we're going to be about, defining things properly. So anyway, on the Madison Marbury versus Madison, I prefer to it quite a bit in my old times as Marshall versus Madison, because it really boils down to the fact that Marshall wanted to overturn the theory of Madison's about the state courts being the highest court. And so it's pretty clear that Marshall wanted to be the one to set the stage for the Supreme Court. Now, Marshall admitted that he didn't have jurisdiction. Even the type of case, which was an original complaint, was not the jurisdiction of the Supreme Court there. But another issue arises, because even if the Supreme Court at that time had the jurisdiction of that case, we have a problem with the night of the midnight judges being selected, is because the Secretary of State at that time that actually sealed those commissions was John Marshall. So it's an interesting turn of events that, not only does the Supreme Court not have jurisdiction, but even if they did, Marshall would need to recuse himself, being a party to the situation that was before him. So to this day, we're suffering from judicial review, where the Supreme Court seems to make new law and everybody seems to back it up. The media comes out the very next day after the court has ruled. And we all, woo, we got the court ruling. Well, I don't have the court ruling. I'm not going to receive the court ruling. When you go by the Constitution, let's go by it. Let's don't talk it. Let's don't have pieces of it. Let's don't have all these interpretations and then tell everybody, well, it's just the way you interpret it. Well, let's just take it for what it says. It doesn't need interpreted. Now, grant you, we know that the definitions have been changing, and they've been swiftly doing it since the war. So we've got to re-gear our minds to even think in the proper defined words and phrases of the time. There is the complication, which is not necessarily a complication, but it's at least something you need to go through to do in order to receive this. You're going to have to go back and redo your defining words in order to understand the real meaning. So I'm going to close this out, try to keep it short, and in the future we'll bring these things up off and on. And if you need to contact us, you can contact us at dueprocessexplained@gmail.com. Thank you. Have a good day.